So we've looked at what is defamation and what the defences are. Now we're looking at remedies. What can a plaintiff get to help them? Our first remedy is going to be damages. So, of course, to seek a remedy, the plaintiff must first prove the three elements of defamation, that there's a defamatory matter which identifies the plaintiff and is published by the defendant. Then we work through and see if the defendant has any effective defences. If they don't, finally we move on and we look at what the plaintiff can do to make them whole, to put them in the position they would be in as close as possible if the tort had not occurred. So damages are available. If you remember, damages are a common law remedy and they are the payment of money. I keep saying to the Gold Coast group, think of damages as what you get for damage and think of that S as being a dollar sign. So it's damages with an S is an amount of money paid to a plaintiff by way of compensation to assist them after liability has been found. If you look for defamation, you'll see that the Act controls to some degree what damages are available. Have a look in section 22 and I'll also take you to some of the other provisions. In the case of Carson and John Fairfax, the High Court talked about what was the purpose of an award of damages for defamation. It's not like other areas of tort where someone's medical bills might be paid, etc. How can you put a dollar value on loss of reputation? The High Court said a court must look at three things. They have to compensate the plaintiff for the damage to the reputation. This is usually done by a court looking at other previous defamation cases, comparing the severity and types of defamation, finding appropriate comparators, and then putting a sum of money that fits within a range that seems appropriate based on previous cases. In addition, there should be reparation for harm done to personal or professional reputation, and there should be vindication of the reputation. Those damages are going to be placed, given to the plaintiff from the defendant to give a message to the world that the defendant was in the wrong, that the defamatory matter was in fact untrue and unreasonable, that it was a defamation, and to hopefully therefore in some way vindicate the plaintiff and increase their reputation. You'll see that the reparation for harm done to personal or professional reputation can be valued in a range of different ways, and that might be where a plaintiff has directly lost work or been sacked or otherwise lost professional or personal financial gain. That can be calculated by reference to that actual financial loss. In other cases, it's more speculative and the court will look at previous cases for guidance. The vindication of reputation also is something they look at other cases for. There is a possibility of contemptuous or nominal damages. Contemptuous damages are where a person proves, yes, they've been defamed, and no, a defence did not apply or was not claimed. But contemptuous damages are the smallest coin of the realm. They are literally given by the court to signal, well, yes, technically a tort was done against you, but because of the plaintiff's behaviour or because of the overall triviality, which should be a defence but not always, they may in fact give very little to the plaintiff, and that's contemptuous damages. Nominal damages are an acknowledgement that a tort was done, that it was, but that the plaintiff hasn't shown an actual loss or damage to their reputation, or that it may there may be future damage. So that will also tend to be a very small amount of money, a token acknowledgement that a tort has occurred, but not a specific amount, but not a large compensatory amount, I should say. It's slightly different to contemptuous damages in that contemptuous damages are usually done to specifically indicate the court's displeasure with the plaintiff in particular ways, and it will be noted that they are contemptuous damages and that it's the smallest coin of the realm. Nominal damages might be a similar amount or might be slightly more. So how do they decide how much money should be given to the plaintiff? Section 34 gives some guidance and says that there should be an appropriate and rational relationship between the harm sustained by the plaintiff and the amount of damages awarded. The court, when it's assessing that harm to the plaintiff, must also take into things such as has there been an apology, any corrections, etc. Under Section 35, they consider damages they limit the damage for non-economic loss. It was originally a cap of $250,000, but it is an indexed amount since the date of the passing of the Act. How do we index? Basically, there are standard percentages by which it is increased each year, and usually based on inflation, and it's notified in the Government Gazette. You'll learn how to find the Government Gazette in Foundations, I hope, and if not, it's via the Queensland Parliament website. And this is what this section, the declaration in the Gazette, will look like. So each year, the Attorney General for Queensland will post a notice of this type, a declaration, stating what that indexed amount for non-economic loss for defamation proceedings has now increased to. And you can see there it's currently sitting at $389,500 because of annual increases since 2005. There is one situation in which those damages can be increased, and that's under Section 35(2). This is the general damages, not specific economic loss damages. And they may be increased where, as you can see, a court may order a defendant in defamation proceedings to pay damages for non-economic loss that exceed the maximum damages amount, that was $389,500, applicable as at the time that order is made, if and only if the court is satisfied that the circumstances of the publication of the defamatory matter to which proceedings relate are such as to warrant an award of aggravated damages. Aggravated damages are relatively rare, but what are they? Aggravated damages, and quite a lot of them, were actually awarded in Wilson and Bauer media. And the judge there said that aggravated damages are a form of compensatory damage and, where appropriate, form part of the general damages awarded to it, that is the non-economic loss damages, awarded to a successful plaintiff for non-economic loss. Designed to reflect aggravation, that is an increase in the injury, caused to a plaintiff's hurt or injury by reason of some conduct on the part of the defendant. So in Wilson and Bauer, some of the aggravated damages arose from the original circumstances of the deliberate publication of lies and the way that they handled that. But that was increased when, in fact, Bauer media continued to run defences which had no merit, of triviality, for example, and of truth, when they knew that the allegations that they had made were not true and that Ms. Wilson was not, in fact, a serial liar and, in fact, could be believed on matters even without specific corroboration of her every word. They knew that, but they continued to say that those imputations were true right up until the judgment, and that her, the harms, and very real and large harms to her career, were merely trivial. The way that they conducted their case by running what were meritless defences and continuing to assert that Ms. Wilson was in fact a liar, while not bringing evidence from higher members of the company to support their defence of, for example, qualified privilege, were found to be part of the reason for an award of aggravated damage. They had behaved in a way which increased the plaintiff's hurt and injury by their own choices around the conduct of their case and their previous behaviour in relation to the defamation. The judge went on to give some guidance and say an award of aggravated damages may be made if a defendant has acted in a manner which demonstrates a lack of bona fides or engaged in conduct which is otherwise improper or unjustifiable. Conduct with those characteristics will be such as to increase the harm which the defamation has caused or may be supposed to have caused to the plaintiff. A damages award is not usually broken down into components for pure compensatory damages and aggravated compensatory damages. So what that last bit means is that a lump sum will be given for the general damages. Now, while normally that's $389,500 as a cap, could be less, often is a lot less. If it is more than that because of aggravated damages, the judge does not have to say this chunk is aggravated damages, this chunk is your other general damages. It's all put together as one item of compensation for non-economic damages for defamation. There are some other things to think about in relation to damages. Section 36 says the state of mind of the defendant, unless it is related to aggravation, does not increase the damages. So even if someone acted with malice in their original publication, that is not normally considered to increase the compensation, because the compensation of general damages is about putting that the plaintiff's reputation back to a level it ought to be at. You don't get extra. Their reputation is not more hurt because the defendant is a jerk or the defendant is malicious. However, if that extra maliciousness causes the defendant to act in ways which cause increased aggravation of the hurt and damage to the reputation or to the plaintiff, and this is where feelings can come into it. If they're causing aggravated damage to the feelings of the plaintiff or the hurt to their reputation, that's when improper behaviour may become relevant to damages. But if that improper behaviour was merely in the publication of the imputation, you merely act to compensate back to an appropriate level of reputation. The reason why that was published may invalidate a defence, but it won't necessarily cause greater compensation, because compensation is about putting the plaintiff back in the position they would be in if the tort had not occurred, not about punishing the defendant. And in fact, this next section, exemplary damages, which are discussed under section 37, makes that clear. At common law, exemplary damages are damages used basically to show the court's displeasure and to punish the defendant, to smack down the defendant for wrongdoing. They are no longer available for defamation in Queensland, or in fact in most of Australia under the uniform legislation. Another thing that courts will look at to decide how much damages should be given is section 38. Section 38 talks about mitigation of damages, and it gives a list of things that a defendant may do which may be looked at by a court to decide damages should be lower. If a defendant has issued an apology or made an apology, has issued a correction to basically state that what they had previously written was incorrect, wrong, etc. Whether the plaintiff has already recovered damages for a defamation or an imputation with substantially the same meaning. So if they've sued two people over basically the same message given to the public, and they've already got money from one, they won't get the same amount over again from a second defendant. The court will be looking at, well, how much extra damage was done to that plaintiff's reputation that we have to compensate. They won't say, oh, you get this much compensation from one and the same amount from someone else, and therefore you make a profit out of your defamation. It's purely about trying to bring the plaintiff back up to a level where the tort had not occurred, not allowing them to reach a better position. So they will consider, have the previous damages already been adequate, or is there minimal additional damage, in which case there'll be minimal additional damages with an S, the money. They'll also look at, has the plaintiff already brought other proceedings or are engaged in other proceedings against someone for the same or substantially similar imputations. So again, looking at, are they likely to get money from more than one place? They'll also look at whether the plaintiff has received compensation or settlement without having gone to court. So again, this is not about the plaintiff profiting. It is about them being compensated for harm which was done to their reputation. They've already had some money to put them back towards their original position. The court's going to take that into account when awarding the damages with an S, the money, to the plaintiff in the current proceedings. The court, Section 38 says that while those things can be taken into account, this doesn't exhaust all the matters the court could take into account in mitigation. They can look at other behaviours of the plaintiff or defendant that should lead to reduced damages, particularly matters done by the defendant to put the plaintiff in a better position. But it's not an exhaustive list, and the court can take into account whatever is relevant in a particular matter. So that's damages, getting some money. We'll also be looking at other remedies of injunctions and making amends.